Good afternoon, everybody. My name is Sandy Chen. Welcome to the Samfiru Tumarkin live employment law show on Facebook and YouTube. So I am an employment lawyer. I'm located in Vancouver, British Columbia. Our firm has offices in Toronto as well, in Ottawa and in Calgary. My colleagues from other provinces do these shows as well. In case any of our viewers are from other provinces. I'm here for the next 29 minutes or so. We are live. I hope everybody can see and hear me. I can't see anybody, but you can type your questions into the chat box in front of you, and I'll be able to see it on my screen here. And I'll do my best to give general advice, or I should say guidance, on anything and everything to do with employment law. Obviously employment law, a lot of issues can arise out of things that happen at the workplace. Employment law typically encompasses all those issues in a non-unionized context. If you're in a union, I may not be able to help you. If you're not in a union, I may be able to help. So like I said, the next 25, 28 minutes or so, please take advantage. I'll try to do my best to answer anything and everything to do with employment law, severance pay, harassment at work, human rights discrimination, quite a host of issues that I can assist you with. Just by way of introduction, there are a few developments or newsworthy items that I'd like to kind of briefly go over. I like to kind of do this at the beginning, just provide it as a brief update or cool things happening in employment law, and things that have come across my desk in the last few months or so. I think that, and if anybody has a question, please just type it in. I'll stop my blurb and try to answer your question. So I think one of the most common issues that's come across my desk is this remote work, return to work, right? So we've all heard about it. Apple's calling everybody back. I know the other big tech companies, and sorry, let me correct that. Apple's doing a return to work plan where they're slowly transitioning employees back to the office. Google, Microsoft, and I know Amazon, some of them are doing it, some of them aren't, or are leaving it to certain management to the side. So the big question I've had come across my desk a lot is, do I have to go back? Right after 2 years, more than 2 years, probably 2 years and a month since the pandemic hit, a lot of people have been working from home. Offices are reopening, employers are calling people back in. And one of the most common questions I get is, do I have to go back in? The answer is it depends. Classic lawyer answer, but generally, I'll put it in general principles. If you were working in the office pre-pandemic, generally I would say that you have to go back if you're recalled to the office, right? Because that's your physical location where you work from. That was a term of your employment. Obviously, you always have the choice to say no and quit. But in general, if you're working in the office 5 days a week, 40 hours a week, in the office, if you're called back to the office, you probably have a duty to go back. Where it becomes kind of gray is if your manager, if the company made some representations to you, right, during the pandemic about you being able to work from home permanently. And this, this has come up quite a bit for me in the people I've been dealing with. But they've moved. You're working in Vancouver, but you moved to the island, right? Because your manager said, "Listen, you can work remotely permanently full time," right? Or some sort of representation from management or from the company that's caused you to take some actions and move. If that's the case, your case isn't as black and white as the first scenario I described. You could have a case to say no, right? You could have a case to say, no, you told me I could do this. And if you're going to force me back now, that's a fundamental change to the terms of my employment. and that's a potential case where you could try to claim for severance pay. Again, there's nuances. It's a very fact. It depends on what happened in your situation, right? Because every case is different. So I think that if there's been anything like that, you might have a case to say no. Obviously, there's a lot of people that have started work during the pandemic. This is kind of a third category where they started with a company as a remote worker. Um, the contract doesn't really, or if you have a contract, it doesn't really say what will happen in the future, whether you're going to be back in the office, or whether you're going to be able to work remotely on a permanent basis. So, I think in those situations, it's also arguable that if you are recalled, that you don't have to go back, right? Because if you start as a remote worker and the company never said to you, hey, eventually when COVID's over, we're going to recall you to the office, right? You're going to have to work from the office physically. If that wasn't an explicit negotiated term, you could have a basis to say no to the company. So hopefully that gives everybody a general guideline for what your rights are in that situation that you are recalled to work in the office. I mean, for a lot of these people that work at Apple, the Canadian employees, I can't speak for the American ones. It's going to be very fact specific, and obviously that if there's something in writing in their contracts and you'll come back, you work from the office physically and no remote work, that might be it. But there's nuances there as well. So for anybody else that's just joined us since I've started here, please feel free to ask any and all questions related to employment law. I'm going to be here for the next 20 minutes or so. If you type in your question in your text box in front of you, I'll be able to see it on my screen here. And so I'll do my best to answer. So I've got a question here from Kathy. Kathy asks, I'm close to retiring and my company is relocating. Should I resign or would I be owed severance pay? Yeah, Kathy, that's a really good question. You should not resign. I guess it depends on what the company wants to do, right? If the company is relocating and they're terminating your employment, if you've been with the company a long time, you could get as much as 2 years severance pay, right? So that's scenario number one. If they're just terminating your employment, you're going to get severance. If they're relocating and they're saying, hey, Kathy, we want you to keep working for us, right, until your retirement date. But the relocation is, I don't know, let's say you're in Vancouver, they're relocating to Calgary. In that case, a court's going to treat that the same as a termination, right? If the company's saying to you to continue employment with us, you have to move to Calgary, but you live in Vancouver and you've worked in Vancouver for 10 years. That's going to be seen as a termination, right? And that the legal term is called a constructive dismissal. And the basis for that is the location of your work is a fundamental term of your employment. A big change to that that's not agreed to by you is essentially a termination at law or a termination of your employment. So Kathy, I think my general advice to you is don't quit. See what the company does. If the company lets you go before they relocate, you're going to be owed severance pay. And before you sign off on anything, I would go to a lawyer to get the severance package reviewed. Because like I said, if you've been with the company a while and you're close to retirement, you're probably going to be entitled close to 2 years pay. If they relocate, and they ask you to join them in their new location, you've got to, and if it's really far, talk to a lawyer, right? Talk to a lawyer and see what you can do, because they can't just move it across the country and expect you to keep working for them. And you're under no legal obligation to do that. So, Kathy, I hope that helped answer your question. If you have a follow-up, please feel free to type it into the text box there. So guys, I have just a list of things that I found newsworthy. So we talked about the work from home getting recalled issue. The second issue that I've unfortunately had to deal with at least a few times in the last few months is this case of harassment at work. And I'm sure everybody knows harassment when they see it. It's unwanted conduct that's demeaning or insensitive to an employee. It has to be, and I say insensitive, but it's an objective test. And so would a reasonable person think that it was harassment? One of the stories I came across was this general store in BC. It was on the news a few months ago. I've had a chance to review the case. It's quite an interesting case, but it's the facts are pretty terrible. A female employee at a general store was working for this this older person, this older man at a general store, the owner, and the owner propositioned her on multiple occasions, asked her out on dates. This was her boss, by the way. So, a series of sexual advances. And obviously this is clearly sexual harassment. And ultimately the owner decided to terminate this employee, this female employee, because of she rebutted him, right? She rejected his advances. The award was actually, this went before the Human Rights Tribunal, and the tribunal awarded this woman close to $100,000 in damages. And this woman was in her 20s. She was fairly young, this is early in her career. And the tribunal was, to put it bluntly, I think was disgusted by the conduct of this older gentleman, the owner, and decided to award, it was close to $70,000 in lost wages, $30,000 for injury to dignity, which is pain and suffering, the mental distress that this woman had to go through. So I try to highlight these cases because, if you're dealing with harassment at work, especially sexual harassment or these advances from your boss, there are remedies in the law to help you. The unfortunate reality is a lot of these cases aren't reported, or just kind of people drop them and they're not pursued for a variety of reasons that are nothing to do with the legal aspects of it. But there is something to be said about doing something about it and making the employer known that their conduct, it's not acceptable in our country. So I think I just want to highlight the case to let people know that there are some serious remedies at law for anybody suffering from harassment or sexual harassment at the workplace, especially it's from your boss. And that case had some pretty terrible facts. By terrible facts, I mean this woman went through a lot, and so the tribunal wanted to obviously award her something to compensate her for what she had gone through. I mean, firing someone for rejecting your advances, that's almost as bad as it could get, as far as a workplace issue. So I hope, people, if you have any friends or family, let them know of that case. It's called, I believe it's called K versus the general store, the Deep Creek store, and that's a store in Armstrong. So anybody joining us, I have I'm on here for the next 15 minutes or so, answering all questions due to employment law. Please type your question in, and I will try to, and I'll be able to see it on my text box here, and I'll do my best to answer. So we got a question here from Sean. Sean's been on layoff since before Christmas. Your boss keeps saying they'll bring you back, but so far nothing. What are my options here? Yeah, Sean, that's a common situation. It's a good question. I assume you mean so layoff Christmas was what 4 or 5 months ago. Um, if you're not in a union, this is very important, right? If you're in a union, it's very different. If you're not in a union, um, typically a company doesn't have the right to unilaterally place you on a layoff, right? They can't come up to you and say, "Hey, Sean, we're gonna put you on layoff for 4 months," and that's that. Um, you have the right to say no and claim for severance pay if that's what you want, right? If you're okay with the layoff, if you want to get recalled, that's fine too, right? You could absolutely agree to it if you want to. But I think you should just know that, if your boss keeps telling you you're going to bring you back, but they're not doing anything, at this point, 4 months later, you have the right to claim for severance pay if you want to, right? It's called a constructive dismissal, which means that unless your contract says that the company can put you on a temporary layoff, they cannot legally do that without your permission. So your two options, Sean, I guess, are number one, you stay on layoff and hope they call you back and keep following up. Number two, you say you're not going to accept the layoff any longer and you claim for severance. I would speak with a lawyer, Sean, before you take that next step, just to kind of properly assess your situation. Obviously, this is this is your job you're talking about, so you want to make the right decision for you. But just know that you absolutely don't have to just sit there and wait for them to recall you. You do have legal recourse right now if you wanted to. Yeah. So Jay's asking, is there a federal government mandate for loading trucks at a federally regulated warehouse in BC? No mention of vaccination or job. Yeah, Jay, I think for the federal employers, as you probably know, they were talking about um, mandating it for all federally regulated employers, right? Banks, telecommunications. Mr. Trudeau was talking about that, doing that earlier this year. As far as I've heard, that's not happened. Okay. The only ones that are still mandated are trucking, and airways, and I think marine transportation. So in your case, I mean, because you mentioned the word trucks, right, and trucking is federally regulated. I think I don't want to give you the wrong answer, but it could be right. In terms of loading trucks at a federally regulated warehouse, it could be under mandate. And I don't want to give you the wrong answer. I would seek a consult and disclose the name of the company you're working for. Disclose the name of the company you're working for before you do that. Okay, guys. So if anybody has a follow up question, please feel free to follow up on ask something else in the text box there. So the last piece of item. Oh, sorry, Jay, I missed your question there. UPS, FedEx. Yeah, I think, Jay, I think they are. I actually think they are mandated. If it's a company like that. Okay. So the next topic I wanted to get to. If anybody else has any questions, please feel free to chime in here. And sorry, Jay, I'm just double checking my answer to you because I'm actually. Yeah, Jay, I'm not sure if UPS or FedEx would be mandated under that trucking thing, under the federal mandates. I think if you send me an email, Jay, I'll get back to you on that. My contact information should be on the screen, but I just don't want to give you the wrong answer because they're obviously it's not marine or rail or air transportation. Anyways, the last thing I have on my topic list today, I wanted to talk briefly about this the moment of termination and what happens at that point of termination. There are certain things, and I'm only raising this because it's come across my desk a few times this week, actually. And there's a lot of misperceptions about what happens in the moment of termination. So, first of all, I think it's important for everyone to know that you're not required to sign anything on the day of. Okay. The company might offer you some severance pay. You can take some time and get legal advice on it before you sign anything. If you sign a piece of paper called a release, you're essentially agreeing not to sue the company or claim for any more severance pay than they've offered you. So that's number one. Number two, all the work you've done for the company up to the point of your termination, you're entitled to be paid for that work. Okay. So you don't have to sign anything to get your wages. All right. That's just owed to you regardless. All your vacation pay that you've accrued and it hasn't, that you've accrued, you haven't used in a year, you are entitled to be paid for. Number three, there's a certain amount of money that you're entitled to under the Employment Standards Act. It's called termination pay, and it's under Section 63 of the Act. But you're entitled to it's essentially 1 week per year of service, roughly, up to a maximum of 8 weeks. You're entitled to that termination pay regardless of whether you sign anything. The issue that's come up for me, the question I get asked a lot these days is this question of bonuses. And bonuses is where it gets tricky. Okay. If you had worked the entire year up until, let's say, November, and you did not, and let's say you were let go on December 1st, right? And there was a bonus that was going to be paid out to you on December 31st, right? For the work you've done throughout the year. The misperception is that you're not entitled to that bonus because you were let go on December 1st, right? You're not employed with the company on the date of the bonus. That's an often incorrect assumption. Typically in that situation, and I say typically, there's always exceptions, but you would be, if you're let go like a month before the bonus was to be paid out, generally speaking, you would probably be entitled to that bonus. Depending on the nature of the bonus, what you have to do to earn it, assuming you've earned the bonus, right? You've hit all the check marks that earn the bonus. You probably would be entitled to that bonus. And the reason is, if your company had given you proper notice of termination, you would have been working a month in. And so you would have been working on the day you got the bonus, and that means you're legally entitled to that bonus. There's always exceptions to that general rule. But I think people should just be aware of that. Just because there's a date in the future that you're not, in fact, working for the company anymore. You're not going to the office or going to the plant every day. If you've earned that bonus, just because it's paid out later, doesn't mean you're not entitled to that bonus. If you've hit all the check marks to get that bonus, odds are you're probably legally entitled to it. So that's something for people to keep in mind. When you've been let go. Okay, so we've got a few more questions here from Ishak. So Ishak says, quick question. You're on sick leave due to family problems, severe depressed state. Is this a cause dismissal fail in the UK? Ishak, that's I know you're in the UK. I'm gonna UK has the common law just like Canada, but it's developed differently. There's different legislation there. I don't want to answer that question just because I really don't know UK law. I'll say that in Canada, BC in particular, the Human Rights Code will protect people in your situation, right? If you're on a family related leave, or if you're on a medical leave, you are probably protected under the Human Rights Code. And that's because it's illegal to discriminate on the basis of family status or medical status, your medical condition or your disability. is what the Human Rights Code says. So I'm sorry I can't answer your question because in the UK, and I just don't want to give you the wrong answer. But I will say in BC, that's not a reason or a cause to dismiss an employee. So we've got 2 more questions here. One from LB. Can an employer fight you on giving you severance? I have a lawyer with your company and forgot to ask her what after the sent out. How does the process work for getting for it? Yeah, I mean, LB, it's they can fight you in a sense, in the sense it's a negotiation, right? You send an offer to the company, you say, I want $100,000. And the company says, no, we'll give you 50,000, right? That's one particular, that's something that could happen. The employer could say, well, I'll accept your $100,000. So it solely depends on, what the employer wants to do with your case. If a letter's been sent out, I assume maybe an offer was sent out. The employer, they can and they often do fight you on severance, but the fight on severance is how much they want to be paying you, right? And if they don't want to pay you enough, then you can take them to court. And I'm sure you can talk to, if you have a lawyer with my firm, I'm sure you can talk to my colleague about that. Okay, so we've got another question here from Jolana. Your transportation company under federal law, companies in the closing process, 61 years old, you weren't working there 4 years, and so are you able to get severance pay or not? Yeah, Jolana, if you're not in a union, I assume, yes, you should be getting a severance package. Because you're, at 61 years old, the law assumes that it's going to be tougher for you to find a job than someone who's 21, right? So your severance package should almost be, all other things equal, it should be bigger than someone who's younger than you. If you've been there 4 years, obviously that's not a short period of time. So absolutely, you should be getting severance pay. The fact that the company is closing or the location is closing is not a reason that excuses from severance pay. Okay. Bankruptcy is a different situation. The only situation, Jolene, in your case, I think, if they gave you working notice, right? If they said to you a year ago, like, hey, the plant's going to close down in a year, here's your working notice. That might be a different situation. But that working notice is your severance. So I guess the quick answer to your question is yes, they should be paying you or giving you a severance package. Okay, so Bruce asks, are all lawyers making 100K straight out of law school? Or is that more of a myth? Bruce, just ask employment law questions. I don't know the answer to that. Salvatina, do you get severance pay if you resign as opposed to getting fired? I belong to a union. Salvatina, yeah, you most of the times you don't get severance pay if you resign. And in the unionized context, it's very different because you have a collective agreement, which sometimes dictates the amount of severance pay you get, right? And I think that I say most of the times you don't get it if you resign, because sometimes if the employer does something that causes you to quit, right? If the work environment is so toxic that it's just impossible to go on, you can quit and get severance pay. If the company cuts your pay by 50%, you can quit and get severance pay, right? So I guess to put it in simple terms, if there's a good reason, that's not the legal term, but if there's a good reason why you quit as a result of what the company did, there's always a potential for you to claim for severance, even if you did resign. So we've got Bruce, just a myth. So Jolena, we've got I got to see your follow-up question from you. You've known about the closing since 2 weeks ago. How much can the severance pay be? Yeah, Jolena, I mean, it depends, right? For you, it could be as much as, I mean, you've been there 4 years for 61. Depending on your position, it could be anywhere from 3, 4, 5, maybe as much as 6 or 7 months of severance pay. And I'm sorry that's a big range, Elena, but it really depends on your circumstances, right? It depends on how long it takes you to find a new job. Depends on your position. Depends on the job market. But I think the range I can give you probably 4 to 6, maybe as high as 8, depending on all those factors. Like that range could be completely off if you tell me something else that obviously we can't talk about on here. But I would encourage you to go speak with a lawyer, Jolena, and as soon as you can, just to get an accurate assessment of what the severance pay you should be getting. Okay, so I think that was the last question. And my time here, I see it's 1:31. So I will be back in 2 weeks. Like I said to Jay, I think Jay Cha was asking about the federal, one of the UPS or something. Please feel free to contact me, email me. I didn't want to give you the wrong answer. So, email me and I'll be able to find it in like 2 minutes. And I'll be able to tell you if it's federally regulated or not. But thanks everyone for joining us. I'll be back in 2 weeks. And my colleagues from other provinces will be on here as well, in case anybody's from Ontario or Alberta. So I hope everybody enjoys the long weekend.